Good morning, good afternoon, and good evening. My name is Elijah Dominguez, and this is World United Press. I want to do a video today in which I will be talking about the state bar in the state of California. For each state it differs, but each one has to register because it is a corporation. Just look into your codes. Policies and procedures. If you look at this, you can see here this is the State of California Bar Association. This is actually printed from their website, as you can see there at the top. If you look that up, it's C003312. They actually have another one, but if you look very closely at it, it was registered in 1901. Keep in mind, this is very important. Also, look, it's a domestic nonprofit, but yet they have lawyers who are getting paid. And the term is also expired if you look closely there. And again, it goes on to another one, C001748. As you can see on this one, I highlighted some of them. I since then have misplaced my yellow marker. I need to get another one. I just need to get a bunch of yellow markers, highlighters, to make it easy. The assembly number, bill number 3249, chapter 659. On the very first three lines, first three paragraphs, state that it's a corporation, it's a business. Now, okay, this is well known. Let's see. Again, this is the business registration. And I wanted to show this because this is in their own personal paperwork. The State of California Bar. And it states that the California Bar Association is in San Francisco, 50 years from the date of its incorporation. Now keep in mind that in 1885 they were abolished. And then they were again later abolished in 1996. And that has not been overturned since. And their purposes, which if you go to the next page on it, you'll find their actual purpose of the organization. It's a corporation, and it's a corporate name of the California Bar Association. Excuse me, I'll read that again. The association, known as the California Bar Association, was held in office of the Association of the City and the County of San Francisco, State of California, 17th day, or May 1901. Now, while I'm talking about 1901, I want to show you this document. This is from the California Bar's Bar Journal. This is from like their personal website. And if you look closely there, I'm sorry, I'm just gonna pull this back actually, cause you can zoom. I'll try to get in as close as I can here. Get a good shot. Oops. Stupid single piece of paper. You see? And on the top, if you look at it, it says State Bar celebrates its 80th anniversary. And when the California Unified Bar was launched in 1927, but wait a minute. The document here from the corporate paperwork says it was in 1901. Those conflict with each other. That's interesting, right? And so I started looking further, and I looked into 6 business and professional codes, 6001 and 6002, which gives them their bar license. And I have noticed, again, discrepancy there's a discrepancy. If you noticed here, why they weren't accepted, because they have no registered agent here. There's no registered agent, so you can't be, in the state of California, you can't be granted a business without having a registered agent or registering yourself as the agent. I don't recommend registering yourself as the registered agent. I recommend always trying to use a second or third business. Again, in the request for proposal, the first line, 1927. So it was made in 1927. Now, okay, that's really strange, because now it's, it's no longer an applicable business. It's an out-of-date business. If it's 50 years up to date, the Secretary of State does not even acknowledge them as a business. Does not even acknowledge their existence. I got a Freedom of Information request from a Lewis Turner from the State Bar's Attorney Regulation. It says Attorney Regulation and Consumers Resources, State Bar 180 Howard Street, San Francisco 94105. Phone number 888-800-3400. You can ask them to yourselves. If you want to email them to, it's attorneyregulations@calbar.ca.gov. Now, I want to show you this, because this is the Freedom of Information request, well, part of it anyway. And I'm requesting information from the State Bar. And the State Bar decided to write back in response via email. Your email request for copy for bar license is assigned to the State Bar of California for 11 different attorneys listed on your email. I had a lot of district attorneys and a lot of public pretenders on there. Gotta make sure you get them licensed, their oath of office, their acceptance letters. You need all of that. That's all important. It's all towards standing and relevance towards them having any standing of actually holding it. See, we're not attacking the courts, we're attacking the party that's bringing this case. Now, in response to your request, the State Bar does not issue a physical license. And understand, I want to read that again. In response to your request, the State Bar does not issue a physical license and is unable to provide such documents because it does not exist. The State Bar functions as an administrative of the Supreme Court, administering regulations of practice of California under state law. No, they're more just like here we're going to take your complaint, and we may do something, we may not, but it's more of just taking note, for maintaining records. Well, if the responsibilities are for maintaining records, wouldn't the responsibility be also to make sure you have that record, the physical license, just in case somebody was to ask for a physical license? The State Bar does not either authorize to issue a physical license, no, but they hold an administrative to the Supreme Court who does. So they should be able to gain access to such documents. So see, they use language. We do not issue a physical document because it does not exist. And then they go on and say, well, they are responsible for holding records, but they don't actually have that record or physical license which they should have access to. And this is the whole Freedom of Information request. Sorry, my hand is on the writing there. Lewis Turner, as you can see. State Bar does not issue a physical license. It's still at the very bottom. It's here at the bottom, the last paragraph. Last paragraph on this sentence, but you can see here that they decided to not issue a physical license. Now, I have asked for a whole bunch of stuff. They do have these records. They just don't want to turn them over. You know, I have a whole bunch of pages I've requested. And there was more, but I don't want to take too much of this video. But you can see here, I have quite a few. Hold on here a second. As you can see, I have quite a few. I made a lot of requests towards the bars and licensing of the attorneys, which is important in the case. Now, I got this document from the Corpus Juris Secundum. I want to thank urlaw.org, who has been very insightful in teaching me and helping me. I recommend urlaw.org. The Corpus Juris Secundum, Volume 7, Section 4. Now, judges hate this, but once you put it into paperwork, they have to accept it. Remember, appellate courts is where the buck stops. But this is the actual Corpus Juris Secundum. It's 2 pages. You could look up Corpus Juris Secundum, Volume 7, Section 4. Again, just so people can see it for reference. And now I want to read some very important stuff from there, because people should know this. This is the right for the people to know. This is Section 4 of the Corpus Juris, Volume 7. The first duty to the court is to the courts and to the public, and not to his clients. And wherever the duty to his clients conflict with those he owes as an officer of the court in the administrative of justice, the former must yield to the latter. The office of the attorney is indispensable to the administration of justice, and intimate and peculiar in the relations to all the well-beings of the court. The well-beings of the court, because their first duty is to who? The courts and to the public. But remember, we're not the people. Erie Railroad versus Thompson, 1939. So keep that in mind when you go into court. Always have everything documented, papered and documented. What is the legal relationship? This is sections 2 and 3. The term attorney is the term is synonymous with attorney. Therefore, anyone advertising himself as a lawyer holds himself out to be an attorney, and an attorney is a counsel at law. And so anybody calling themselves, anyone who appears in interest or moves for another action with respect to a matter before the legal matter, and such person appears as an advocate, as in the statute regulating practice of law, implying a representation distinct from officer or any other regular administrative corporate employee representation. That's important to remember. Corporate employee representation. If you've been watching my videos and you've been looking down at the comments below, you will see that I have been posting a lot of legislation, and I'll post again this. Yeah, no, this just goes to show that the people are represented again by. We are a corporate interest, State of California LLC. So this is in England, the colonies, a barrister is a person entitled to practice as an advocate or a counsel in the superior court. A solicitor is a person who begins, whose business is to employ, whose business it is to employ the care and management of suits depending on the Court of Chancery, in its greatest majority of the state of the Union, where the equity are both administered by the same court. It has naturally become the two offices of attorneys at law and solicitors of chancery. and the consolidation. Although the federal equity practice term solicitor is often generally used, but in some states officers of solicitors in chancery is a distinct separate in office. A client who asks for advice in direct question of practice of law has committed or commits has caused his management to prosecute a claim of the defendant, a suit in a justice, or retain an attorney is responsible for his or her fees, and whom the attorney is responsible for the management of the suit. Remember, keep in mind that all cases are civil. All matters are civil. And as you can see there, they have no standing. They literally have no standing to practice law. They are out of date, out of business. They have no right to do so. Now, to an attorney, the professional advice clients are called wards of the court in regards to relationships with the attorney. Now, this is very, very important. While it has been broadly stated that right to practice law is not naturally constitutional, but is the natural privilege or franchise to practice law, and it is a matter of grace, but for those who qualify and have learned from moral character. The right to practice law is not constitutional, nor the right to practice. What is a ward of the court, though? Now, we understand an attorney works for the court now. We understand that they are unlawful. They have no authority to do so. We have established clearly that their interest is abiding by the court's interest, which is the state, and the state has an interest in the matter. Now, when you hire an attorney, you become a ward of the court. A ward of a court is an infant person of unsound mind placed by the court under the care of a guardian. Davis Committee versus Looney, 290 KY 644 162 SW 2D 18990, and Montgomery versus Erie. Their rights must be guarded jealously, meaning the rights of the attorney in Montgomery versus Erie. I also recommend reading this because they are also supposed to guard our rights as fiduciaries and beneficiaries. Their duty as a trustee is to make sure that they get rid of the debt. See, what we want to do is get rid of these attorneys and put us in what is called propria persona, which is one owns person, formally and ruling of pleading that pleads jurisdiction in the courts must plead in propria persona, because if pleaded by an attorney, they admit jurisdiction as they are an officer of the court, and it is presumed to plead and have obtained leave in which the jurisdiction see pro se. Now, when you hire an attorney, obviously, 1, you become a ward of the court. 2, you have a private business. And we've established this now. We've established that they're a business and that they are making people into what is basically infantileness due to the fact that they are hiring attorneys. Now, I was looking at 6... hold on here a second. Let me find my book. I thought I saw it this morning. I'll just do that one later. I'll do another video on that later. So, when I did that Freedom of Information request, right, I went onto their website first, found this bar license. But remember that in the Freedom of Information request, they do not give you a physical bar license. So then I also received an oath of office. And at the bottom there you can see a license number. They make a reference to the license number. But you can also see that there's flaws because look closely. Judicial Superior Court. That's not a legible signature. And that's an actual superior. That's from the Superior Court. Stamped, official. They forged an oath of office. This is for one of the DAs, another DA in Contra Costa County, Ashpal Singh, who again, it was forged by who? That now head DA, Diane Becton. We'll get to her in a second. But the only one that I have found that was maybe lawful, the oath of office being lawful anyway, not the actual physical bar license, because this lady has also committed felonies too, so she has actually violated this bar. But you want to have these because when you put them into the court, it lets the courts know that you have the oath of office and we're not playing games with you. So when you have this, she's the only one that actually has maybe a lawful oath, but her physical bar license is not valid. Now, this was Jessica Murad, and I believe it was signed up by a district attorney. Now, I don't know whose signature that is because it's not legible, which means it's not valid. But it was signed by a district attorney office. Again, they forged Jessica Murad's oath of office. Now, who's this? Colin Ann Gleason. Another one who has committed fraud in Contra Costa County for the Judicial Court. I mean, it's ridiculous. Again, no, I asked for the bar license certified. I asked it for it certified. Obviously, this is not a certified copy. Obviously, this is not a lawful copy anyway. I'm going to talk with Scott Alonso and see what I can dig up now that I have this. Now, here's Whitney Goins. She was also signed by a U.S. magistrate, but she has also interfered with criminal cases, violated rules of ethics of courts, and continues to violate her rules and ethics of lawyers' law. Now, I want to show you as well this. This came from the appellate court, but it doesn't even have a signature. And it's signed, but it's not even legible. And it's dated 2009 in December for a Jeremy Lalal Seymour in 2009. As you can see there, look, no signature. Where's the signature? Where's the person signing saying, hey, this is lawful? No, this is not a lawful oath of office. This is a criminal behavior. These are some of the case laws that show that they're actually for profit, not a non-domestic. So, I mean, you can see clearly again, here's more complaints. It does nothing to help, but it lets me know that I have, documented it, and it's also good for to document so that you have so you have these, so you can say, hey, look, I filed complaints against these people, it's not being heard, and you put these into the court, and that also will affect an appellate hearing. So when next time you go into court and you think, well, I'm going to have my attorney's going to get my case dismissed, and they're going to protect my rights. Remember that you have no rights. The attorney is not going to help you. They are not lawful. They are de facto. They are actually criminal in what they are doing, and they should be actually arrested, detained, and shut down. Thank you for watching. Share, comment, like. Tell me what you think of this video. I put a lot of work and effort into this video. If you like it, thumbs up. If not, thumbs down. Thank you for watching. This has been World United Press. I am Elijah Dominguez, and until next time, be safe and many blessings towards you.